begin with oral arguments in the state of Ohio versus Anthony Bryant. It's case number 19AP0017. Both parties are represented by counsel, so each of you will have 15 minutes to present your arguments. The appellant may reserve up to 5 minutes for rebuttal. I'll keep track up here, so if you're, just let me know how much time you want to reserve, and I'll try to let you know.
Your Honor, we would ask for 2 minutes.
2 minutes, okay. And I'll remind you when you get close to that point.
Thank you.
If there are children or victims involved, then we ask that you use initials as opposed to names. And that's because we do videotape the oral arguments, and they're played on the court's YouTube channel. And having said that, we've read the briefs and we're prepared to proceed if you are.
Thank you, Your Honor. May it please the court. During the trial of this case, the court ruled that the state's witness could testify to the fact that her daughter, the alleged victim, R.S., had admitted to her that the crimes never happened and that her grandmother had put R.S. up to saying that they had. This was elicited on cross-examination of the state's witness, Kelsey Sheehan Sowers, over objection by the state not once but twice. Each time the court ruled that the evidence of recent fabrication was admissible. However, upon discussion of a different evidence issue the following day, both appellee State of Ohio and appellant Bryant agreed that the court clearly confused its ruling, admitting this key defense testimony of recent fabrication with the second ruling made just before that, denying the admissibility of other testimony based on the state's objection that it was speculation. I refer to transcript 211. Upon the announcement of the court's now conflated rulings and the reasoning offered for that decision, a day after those same rulings, the court caught both parties by surprise and now declaring that the testimony of the state's witness, Ms. Sheehan Sowers, was, quote, not in the case, end quote. Indeed, the court emphatically asserted 4 separate times at that point, quote, so far as I'm concerned, it's not in the case, end quote. And when pressed by the state on this point due to its confusion and asking the trial court, quote, the court is ruling that it's not considering Kelsey's testimony yesterday, talking about R.S., saying in her presence that this never happened and Gloria put her up to it, question mark, the court responded, right, that's correct, end quote. The court's error only became manifestly clear when the court recounted its 2 rulings as the court recalled them at the time of this decision, a day after it had admitted the evidence of recent fabrication from state witness Kelsey Sheehan Sowers. The court, by its own explanation, revealed that it had clearly conflated its first ruling, denying the admissibility of testimony on the basis of speculation, with the court's ruling immediately thereafter admitting testimony of recent fabrication of the core accusations of the indictment. This failure to recall its own rulings of testimony as it had actually occurred during trial cannot stand, as it is directly in conflict with the facts and the testimony, and in fact denies the appellant his right to defend himself as guaranteed by the Due Process Clause and the right to a fair trial.
But it was raised in the briefs, and I'd like to hear you argue about it this morning. The fact that the counsel did not object to it. Judge,
first of all, it was admitted to begin with, so there was every expectation. This caught everyone off guard a day later, and clearly this was the defense, recent fabrication. But at the time that this then came up in yet another conversation between the prosecutor and Judge Wiest about this ruling that he had made and was making at that point to say that it was not in the case. Defense counsel, honestly, after hearing 4 times that it was not in the case, one could argue may very well have been appropriate in standing up and taking issue with that. I ask you to consider the practical ability of a defense counsel to ask the trial court to stop the case, to ask to read back portions of testimony from the day before of this witness, and to reconsider the conflation of testimony between 2 different rulings, and whether in a bench trial that would have been really practically possible in reality so as to protect his defense.
But from the excerpts in your briefs. Now, I've not read the actual transcript yet, but from the excerpts in your brief, it doesn't seem like the attorney actually even said to Judge, I think you're confused. You actually allow that evidence in, and now you're not going to allow it in?
Well, you certainly can tell from the excerpts that the state is that confused.
I
So-
understand, but my point is, don't you have a duty to stand up and say, hey, this is a mistake? You say it in a nice way, but...
I would concede that there's every possibility that this court could, in fact, apply whether there's a prejudicial per se error here because of it being in the constitutional context and whether, in fact, it's harmless or not. Truthfully, I don't imagine that this court could see this as harmless since it's the very core of the defense, one. And two, if in fact it is defense counsel's ineffectiveness that caused him not to stand up and object and to ask for clarification and to ask for, to object to the failure to admit this evidence, in fact that would at least be ineffective assistance of counsel fairly clearly, since that was clearly his defense from the start, as the state concedes in its own brief. The state had openly admitted in its own brief that the court, quote, confused its evidentiary rulings on page 9 of its own brief. Nevertheless, the state would have you affirm a verdict based on such admitted, obvious, crucial mistake on the part of the trial court. And you have instead been asked by the court to enforce such an erroneous ruling, prohibiting testimony of recent fabrication in this case. To argue, as the state does, that this key error by the trial court was somehow waived by the defendants does place the burden entirely on him, as opposed to considering the circumstances as I've just outlined. Ultimately, quote, a reviewing court will not reject an exercise of the court's discretion unless it clearly has been abused and the criminal defendant thereby has suffered material prejudice, end quote, from State v. Adams, 9th District, Medina, number 13 CA 0008-M. This evidentiary ruling, based upon the court's confusion of the two of its rulings, which ultimately prohibited the defendant's defense at trial of actual innocence, was nothing less than prejudicial error per se, for which reversal of the judgment and entry of a final judgment as a matter of law for the appellant is the proper remedy pursuant to Ohio Appellate Rule 12b. In essence, the court made the right evidentiary decision to admit the evidence at the point of its being offered, and then simply decided sometime more than a day later that this same evidence was, quote, not in the case. Affirming this denial of the very defense that was allowed the day before while actually in trial in favor of a mistaken confusion over two evidentiary rulings would mean that no advocate could ever trust a court's ruling of admissibility upon the announcement of that ruling.
Counsel, let me ask you this,
Yes.
because you've gotten into a point that I was thinking about. Let's just assume for a second that the court didn't confuse itself, that it just changed its mind. Doesn't it have the right to do that? The case is still pending. It can reconsider the admission of evidence.
Well, if that were the case, I think it would be incumbent upon the court to have at least brought that to the fore at the time of the original ruling and have that discussion at the time that this issue came up, when the witness was still on the stand. Now, of course, the court could consider allowing the witness to be brought back and make provision for further discussion of how to handle that. And I have been in some situations where I think the court finds itself in a difficult place, as do all the advocates. And we've all had, I think, probably some issues of this kind where, truthfully, the exhaustion mentally and otherwise of cases just kind of wash over us. And we do have a moment in time where we kind of interlock or conflate things a bit. But this was so very clearly an issue that this court decided not once or twice, but was 4 times very emphatically not in the case, that it ultimately denied the defendant his very right to defend himself, in essence. And the fact that this is something that happened so much later on in the case essentially eviscerated his opportunity to now come up with any kind of other defense, and ultimately has ramifications in future cases. If a court could in fact decide to reverse itself on a major ruling in this case, in a case a day, 3 days, 4 days later, obviously that could change the very nature of the trial entirely.
What was the argument as to the reason why it was even admissible?
At that time, it was an issue of recent fabrication. Again, that would be admissible, and the state doesn't deny nor even object to the fact that it was, I mean, it objected at the time, but it did not state the basis of that objection, Your Honor. So as to what they believed was the basis properly to object to it is something that probably properly asked of the state. But
Well, it's your burden to have the evidence admitted.
it is.
Because obviously, that statement was a statement that was made out of court.
Right.
The little girl did testify.
And it was impeachment, Judge.
Yeah, but I know the state objected at the time of trial in regard to the
Right, and
impeachment.
under 607 or 616 of the Ohio Rules of Evidence, one could use it as impeachment of another witness's testimony. So RS had in fact said, no, this is my testimony when asked by defense counsel. And then when her mother got up and she was asked, have you ever talked about this with your daughter? And she says, well, yes. And did she ever say that nothing happened? And she says, yes, and there's an objection from the state. I mean, clearly that's a impeachment of the original child victim here in their testimony. So under 607, Your Honor, respectfully, we believe that would have been the way that this would have been admitted. Clearly, the trial court admitted it after having had an objection from the state of Ohio, so it believed that there was a basis for it, too. It was only a day later that, again, it was not just a question of, well, we believe there's no credibility to that, but in fact, it's not in the case, which is a complete, essentially, a dispensing of that witness's testimony altogether.
But you asked the little girl, and she said she had never said she hadn't said it.
That is what was testified to prior, yes. And
I'm
prior-
just not sure how it was coming in to begin with. That's okay. I've taken up a few
No, I
times.
understand. Ultimately, the state has the argument before the court that, well, there was overwhelming evidence of guilt anyway. We couldn't be more in conflict with the state there. And frankly, the evidence is proof of that. The entire case rests undeniably on whether the victim's testimony is believable or not. And the state of Ohio, and the court, the trial court, ultimately was quoted as saying, quote, we have the 5-year-old, now 6-year-old, who gives extremely inconsistent statements about whether there was sexual conduct or not, end quote, transcript 287, which was the basis for the trial court ultimately finding that counts 1, 2, 3, 4, 5, and 6 were not proven beyond a reasonable doubt. So as to the credibility of the first 6 counts, the trial court clearly thought that was an issue. But more importantly,
The trial court
perhaps,
also said, I think he did it, I just don't think you've proven it beyond a reasonable doubt.
well, since the legal standard continues to be beyond a reasonable doubt.
I understand, but my point is, I wonder if it was so much, not so much he didn't believe the child's testimony was confusing.
Well, and I guess confusing would be one thing, respectfully, Your Honor, but I guess the legal standard ultimately has got to be the same in each and every case, and ultimately the court held, based on a great deal of experience, as I understand Judge Weiss to have, that there was not sufficient evidence beyond a reasonable doubt because of that inconsistency, because it wasn't just one inconsistency. He described it as extremely inconsistent statements, which out of the mouth of the victim with no DNA testimony, no physical evidence to link the appellant to so much as having touched this child or even spat on this child, does in fact put the entire case in a much different posture.
I just have to ask this question. Are you suggesting that the child's credibility was, that the trial court thought her credibility wasn't very good because of the inconsistencies, and so therefore she shouldn't be believed in regard to the other allegations she made, because the court said very clearly he believed her with that?
Hey,
Well-
before you answer that question, you're at 2 minutes now, so you can have a long answer, and You'll be into your
No.
rebuttal.
I'll withdraw the question.
That's okay.
Just go ahead and save your time, that's fine.
Well, I would say only that, just to finish the thought here, I would say only that clearly the trial court thought it was extremely inconsistent as to counts 1 through 6, the most serious of all the counts. The fact remains that it's the same child testifying about the same conduct on the same day, and with all due respect, while the trial court says it believed the child, nevertheless, the trial court in 3 out of 4 counts, or 6 out of 8 in this case, decided that it didn't believe it beyond a reasonable doubt, and there is no other evidence but the child's testimony. Thank you.
1 minute and 30 seconds then for rebuttal.
Thank you, Your Honor. Appreciate it.
Counsel, you'll have 15 minutes, obviously.
Good morning. Thank you, Your Honors. May it please the court, counsel, Andrea Uller for the state of Ohio. It's the state's position that there are no valid assignments of error that have been raised in this appeal. With respect to the issue asserted in Mr. Bryant's first and fourth assignments of error, Mr. Bryant has forfeited all but plain error arguments on appeal. As it's been noted that he failed to raise these arguments at the trial court level. And as this court is aware, plain error is error that, but for the occurrence of which the outcome of the trial would have been different. We do not have that standard met in this case. Specifically
Well,
with...
he's saying, and doesn't he have a good point, that it's just her testimony. And the trial court has already said it didn't at least find her credible because of inconsistent statements on the other counts. And now the evidence that the defendant wanted to bring in, and the trial court said he could bring in, that was basically his defense, that she made it up, the trial court either confusingly conflated it or just changed his mind, whatever happened here. So how do you say that wouldn't be plain error then?
So with respect to that first assignment of error, when you first stated, there's no other evidence in this case than the victim's testimony, it's true that the 5-year-old victim did testify at trial, as did her grandmother, who she reported this to. In addition, the child was interviewed at the Children's Advocacy Center, and the entirety of that CAC interview was admitted into evidence in this proceeding, where the trial court had reviewed and heard that evidence, and that's where he noticed that those inconsistencies in the statement, because what happened was in the CAC interview, the child victim stated that Mr. Bryant had spit on her and wiped his pee-pee on her pee-pee, is how she had worded it, and then she had also stated that he inserted, touched his penis to her butt crack, and so that's where we had, at trial we just had that he spit on her and wiped his penis on her vaginal area, and that's where the trial court was aware of those inconsistent statements. But with specific respect to Mr. Bryant's argument that he was prejudiced to deny their trial because he didn't get this evidence, the trial court appears to have confused its rulings and excluded that testimony by the victim's mother. The 5-year-old child had, in essence, recanted, said this had never happened, and then her grandmother put her up to it. You don't get to that evidence coming in does not rise to the level of plain error, because but for that evidence coming in, the outcome of the trial would not have been different. We had that CAC interview, we have the child's testimony, we have the grandmother's testimony, we have testimony from Detective Lemon, who indicated that the mother, he obtained a DNA sample, and from the mother, and spoke with her, and at no time in his investigation did she ever say, that the child had indicated that this never had happened. We also have the mother's own testimony that she never spoke to the child about this incident. She never asked her child what happened, during this incident. And so I do believe that we get into, a credibility issue that was likely readily apparent to the trial court, so that even if this evidence had been admitted, you do have all these other factors to weigh, so you just don't rise to that. But for this evidence coming in that she had, recanted, in essence, that the outcome of the trial would have been different.
The appellant is also arguing that the state really isn't contesting the admissibility of the evidence, but at trial, I know the state did object and say it wasn't admissible and it wasn't properly before the court.
Yes, and in the brief, and I looked at that, and honestly, and looking at it, because we got hung up on the confusion of the rulings, and the trial court, permitted the testimony to come in that the state had objected to, but it was overruled. That testimony was going to be coming in anyway, and so I didn't go into whether that was the proper method to impeach a witness. I do think that because we had that prior testimony from the child where on cross-examination, the child was specifically asked by defense counsel, did you ever, tell your mother that this didn't happen? No, was her answer. Did you tell anybody else, did you tell your mother that your grandmother put you up to this? No, and so, at that time, the proper impeachment method, I do believe, would have been to try and bring in any testimony in contravention to her testimony through his witnesses, or to maybe, she's only 5 years old, was likely the issue that he couldn't, then try to, he didn't impeach the child victim. But overall, we have an issue where the trial court admitted that evidence, let it come in over the state's objection, and regardless of whether that evidence was admissible or not, we still don't get to that level of plain error because the outcome of the trial did not hinge on the victim fabrication as Mr. Bryant would lead this court to believe. I would also note Mr. Bryant, in essence, alleges that for the same reason that the evidence of the victim's prior fabricated rape charge is admissible, evidence that the victim has fabricated the charges that the defendant is currently on trial for is admissible. And this kind of steps you back to what I was trying to say. Even if mother's statements have been admitted, that it cannot be said that the outcome of the trial would have been different. And then Mr. Bryant alleges that mother had direct knowledge of the fact that the allegations were false. But again, we have all of that, the victim statements that prove otherwise, as well as Detective Lemon, just to reiterate that point. If I may, looking at count 7 and 8, because assignment of error 4 that talks about the carbon copy indictments, I believe that standard of review is also, he waived this at trial court level, and so it's only proper for this court to consider under the plain error analysis. And I did, a few weeks ago, had supplemented this, the record on this case, or the authority, with State v. Scott, which is 2017, Ohio 2642. It's a 9th District case that I had Supreme Court case law that indicated that you cannot, you have to rectify this error at the trial court level if you're going to have any issues with the indictment. And that did not happen here. And State v. Scott reiterates that you cannot, you have to raise this at the trial court level or else you have plain error. But Scott also recognizes that the failure to provide the requested bill of particulars to the trial court's attention at the time when it could be remedied, that also rises to plain error. And I know that the record, Mr. Bryant, kind of alleged repeatedly throughout his brief, he brings in the failure of the state to provide the bill of particulars. And I just wanted to make it more clear to the court that it's the state's position that that bill of particular was filed, the request was filed right at his counsel's notice of appearance into the case, and there was discovery was replete throughout this process. The record shows multiple times that the state supplemented its discovery, and at no time did Mr. Bryant raise these allegations that he was unaware of the differences between the alleged carbon copy indictments between count 7 and 8. The state does not disagree that the count 7 and 8 are identical. However, we differentiate the case law that Mr. Bryant relies on being the Valentine case. That the Valentine case involved 20 carbon copy charges, and the time frame spanned 8.5 months. Here we have, two indictments with respect to the GSI, 8 overall, but they all were with respect to that same, time frame, that same date. And so between the discovery and the pre-trials and, the failure to raise this at the trial court level, I don't think that there's any merit to any arguments with respect to, deficiencies in the indictment or carbon copy indictments. And that would be the same position the state has with respect to Mr. Bryant's third assignment of error regarding being sentenced for 2 crimes and punishments, twice in violation of double jeopardy clause. Here we have 2 separate counts of GSI. The trial court found, the spitting and the wiping to be sufficient sexual contact within the definition of sexual contact related to GSI. And we have that, those 2 different acts, and so that's not in violation, it's not the same crime. It is proper to be found, guilty for those 2 separate crimes. And there's also, although the state anticipated, based on the CAC interview, it was likely touching, his penis to her vaginal area and his penis to her butt crack. There's case law that indicates in State v. Schaefer, which is an 8th district case, the fact that some jurors might have found the appellant committed one but not the other type of rape in no way reduces the reliability of the appellant's conviction, because the finding of either type of sexual contact is sufficient to establish the facts of rape in Ohio, and the same is true with respect to the sexual contact in this case. Touching on Mr. Bryant's ineffective assistance of counsel claim, this ties back, I think, actually with respect to his first assignment of error, that for one, with ineffective assistance of counsel, that we all know that trial strategy is, one ground that normally don't find ineffective assistance of counsel on here. And I think it's clear from the transcript that the trial court's confusion here occurred when the prosecutor indicated that it would like to call RS's teachers to refute the allegations of victim fabrication. And because RS had made prior consistent statements to her teachers, which would have been admissible under Evidence Rules 801 and 803-4. And so at that time, the trial court, the state had asked that they went through this whole whole discussion on what evidence was coming in, what evidence was staying out, and it very well could have been trial counsel's strategy, to not object and to not keep pursuing, the victim fabrication testimony to come in faced with 3 potential corroborating witnesses who could bolster the victim's statements and testimony, as well as Detective Women's testimony that this had never been disclosed prior to trial, and the grandmother's statements, she testified here, and then her involvement in what her granddaughter disclosed to her, and that can't be discounted. With respect to Mr. Bryant's arguments about the manifest weight of the evidence and insufficiency of the evidence, I think that the manifest weight of the evidence argument, there was scientific evidence also that was presented in this case, as well as to the victim testimony. And yes, the scientific evidence, wasn't strong, but there was evidence that was presented by, I believe it was Dr. David Ross, and he had testified that amylase, a component of saliva, was found on the interior forward crotch area of the victim's underwear. And then we also had an expert from BCI testify that Mr. Bryant's underwear came back with a mixed DNA profile that included Mr. Bryant, Miss Sheehan Sowers, the victim's mother, and then another component that couldn't be excluded to be RS, but it couldn't be included either. But that scientific evidence, coupled with the CAC interview, where RS disclosed in much more detail, she even drew a picture indicating what had happened to her. I think all of that evidence coupled together the state did meet its burden for both the sufficiency of the evidence test and the manifest weight of the evidence test. jumping to just the point I believe I had already made with respect to the sexual contact, being as defined in 290701B. Again, we have the case law that indicates that the same kind of touching wasn't required, but with the trial court finding that there was the spitting and the wiping, sexual contact as defined by 290701B says any touching of an erogenous zone of another, including without limitation, the thigh, genital, buttock, pubic region, or the person is female at breast, for the purpose of sexually arousing or gratifying either person, is sexual contact. And so here, the trial court found those two separate instances of sexual contact met that definition. They were sufficient. He did indicate that he believed the testimony of the victim overall. He found her credible, but it's a high standard, as we noted, beyond a reasonable doubt. He couldn't get there with the penetration because when the state asked the child victim, was it on, your, and she didn't say, vaginal area to the victim. But the child said yes, and then she said, try to say, did it ever go in that sense, and the victim said no. And so we were, that penetration that was required for the sexual conduct, the trial court just couldn't find, even with the CAC interview, that he was comfortable beyond a reasonable doubt, but he did find the sexual contact beyond a reasonable doubt, and I do think that's proper.
Counsel, your time is up.
Thank you.
Minute and a half. I haven't started it.
Okay. First of all, I'll speak very quickly, I'm afraid. The state's witness with regard to the amylase that was mentioned by the state of Ohio just now did concede on cross-examination that amylase is more prevalent in fecal matter than saliva, and there was no connection whatsoever to the defendant ever found, so that is the only physical evidence that even remotely kind of possibly smacks of, could conceivably possibly being connected at all to this case, though there was never any link made. Secondly, as to the strategy of counsel being somehow to decide not to challenge the court on its rulings with regard to the evidence that I've touched on so clearly, and that Judge Carr has asked me quite a lot of questions about, that strategy would be obviously clearly the most ineffective imaginable, since it would eviscerate one's own defense, which would be about as clear a definition of ineffectiveness as one could imagine. Finally, the very concern of carbon copy indictments is exactly what happened here, Your Honors. There was a allegation and or effort by the state of Ohio to prove that a defendant had committed this offense with the touching of his penis to the vaginal and buttocks areas. But in fact, the court ultimately held, quote, we have the testimony of RS on the witness stand under oath, subject to cross-examination, and she testified about the touching both with saliva and with the penis, and so she testified about 2 incidents of sexual contact with the defendant, end quote. Transcript 285 to 286. Respectfully, there is absolutely no case law in America that we can find that would indicate that saliva is a touching for purposes of sexual contact in the context of 2907.05 GSI as charged. And lastly, we would ask the court to consider ultimately any criminal defendant has a right to definitive rulings on the admissibility of evidence presented that do not change over the pendency of the trial due to prejudicial error on the part of the trial court in conflation of its rulings and unconstitutionally protected rights to defend oneself. Had the evidence been prohibited from the point that it was elicited, appellate could have and would have been allowed to argue the basis to challenge such an adverse ruling right at that time, which would have been the appropriate time to do so. To say that appellant could be responsible for disabusing the court of its mistake the next day and precluding this evidence so as to, as it so emphatically announced 4 separate times that next day, is to deny the reality of the trial and the fact that the court bears the burden on this error. Defense counsel's failure to do so, if seen as applicable, is clearly deficient on its face, as this error denied appellant his very defense and thus a fair trial. Whether it is held to be the court or the defense counsel's burden, it clearly cannot be the appellant, who should be deprived of a fair trial upon any constitutional analysis, regardless of the person or party involved. Thank you.
Thank you both for being present today and providing the court with your arguments. The court will take the matter under advisement and issue a decision in due course. Of course, the clerk of courts will mail each of you a copy of the court's decision on the day it is released, and the opinions are also posted, as you know, on the Supreme Court of Ohio's website.